How long does it take to complete an uncontested guardianship? When a loved one can no longer safely make personal or financial decisions, families often face urgent questions and emotional pressure. One of the first concerns is how long an uncontested guardianship will take and what to expect during the process. In Texas, understanding the general timeline can help families prepare while recognizing that courts move at their own pace and prioritize the rights of the proposed ward. In Texas, an uncontested guardianship generally takes between 30 and 90 days from filing to receiving a final court order. In streamlined cases where all paperwork is accurate and complete, the process may conclude in as little as 4 to 6 weeks. Other cases may take longer due to court scheduling, required investigations, or documentation issues. Even when everyone agrees that guardianship is necessary, the court must still ensure that legal standards are met and that no less restrictive alternatives are appropriate. An uncontested guardianship means that all interested parties, including family members and others with legal standing, agree on the need for guardianship and on who should serve as guardian. However, the court does not simply approve the request automatically. Texas law requires the court to confirm that the proposed ward is incapacitated, that guardianship is necessary, and that the proposed guardian is qualified and suitable. This legal oversight exists to protect vulnerable individuals and applies even when there is no dispute. The timeline begins with preparation before filing. Families must obtain a physician's certificate of medical examination completed by a licensed Texas physician within 120 days of filing. This document describes the nature and extent of the proposed ward's incapacity and is essential for the case to proceed. The application for guardianship must also be completed with detailed information about the proposed ward, the applicant, and the reasons guardianship is needed. Background checks, Judicial Branch Certification Commission registration, and required training for the proposed guardian must be completed as well. Careful preparation at this stage can significantly reduce delays later, especially when guided by a lawyer familiar with Texas probate courts. Once the application is filed, the court assigns a case number and issues citations that must be served on the proposed ward and certain relatives. Texas law requires that notice be provided at least 16 days before a hearing can occur. The court also appoints an attorney ad litem to represent the interests of the proposed ward. In some cases, a court investigator is assigned to evaluate the situation and report back to the court. These steps often take several weeks and depend on the availability of the attorney ad litem and investigator, particularly in busy counties like Harris County. After notice and investigation requirements are satisfied, the court schedules a hearing. In many Texas counties, uncontested guardianship hearings are set 4 to 8 weeks after filing, assuming all requirements have been met. The hearing itself is typically brief. The applicant provides sworn testimony, and the attorney ad litem asks questions to confirm that guardianship is appropriate and in the proposed ward's best interests. The judge reviews all submitted documents and determines whether the legal standard of clear and convincing evidence has been met. If the court approves the guardianship, the judge signs an order appointing the guardian. This may happen the same day as the hearing or shortly afterward. The guardian must then take an oath and, if required, post a bond before letters of guardianship are issued. These letters are what allow the guardian to act on behalf of the ward in medical, financial, and legal matters. Working closely with an attorney during this stage helps ensure there are no last-minute issues that delay issuance of the letters. Several factors can affect how long the process takes, including court backlog, the completeness of documentation, timing of the medical examination, and completion of guardian training requirements. Even in uncontested cases, delays are usually administrative rather than adversarial. Families who are responsive and organized often experience a smoother process with fewer continuances. Navigating guardianship can feel overwhelming, but having clear expectations about timing can ease some of the stress. A knowledgeable lawyer and attorney can help keep the case on track while ensuring compliance with Texas law. The Law Office of Whitney L. Thompson, PLLC is a Houston-based law firm that assists families through uncontested guardianships with care and attention to detail. If you need guidance, you can reach the Law Office of Whitney L. Thompson, PLLC at 281-214-0173 or visit their office at 4201 Farm to Market 1960 Road W Suite 360, Box number 116B, Houston, Texas, 77068, where the law firm works to support families during challenging times.